Do I have the right to a severance package? Imagine this. After years of loyal work, your boss calls you in and says the company is downsizing. You're out of a job. Then comes the big question. Will I get a severance package? Some people expect it as automatic, like an extra paycheck when you leave. Others are shocked to learn they get nothing at all. The truth is, in the United States, severance pay is not guaranteed for most workers. Unlike vacation pay or overtime, it isn't built into federal wage law. Instead, whether you're entitled to severance depends on contracts, company policies, state rules, or specific laws like the WARN Act and mass layoffs. In this video, we'll break down everything you need to know. What severance really is, when employers must provide it, how contracts and policies play a role, what state laws add, and what workers can do if no package is offered. When workers ask about severance, they usually imagine a financial cushion, weeks or months of extra pay, maybe continued health insurance, sometimes even help finding a new job. But legally, things work differently. Severance is not a universal right. It's a benefit that depends heavily on circumstances. Let's unpack this in detail. No federal law requiring severance. The first key fact, the Fair Labor Standards Act, FLSA, does not require severance pay. The FLSA governs minimum wage, overtime, and child labor. But it says nothing about severance. That means, under federal law, an employer can terminate an employee without providing a single extra dollar beyond the final paycheck. This often shocks workers. They assume severance is like overtime, automatic. But unless there's another source of obligation, federal law is silent. When severance becomes legally required. Even though there's no blanket federal rule, severance can still become legally required in certain situations. 1. Employment contracts. If you have an individual employment contract that promises severance, the employer must honor it. Contracts often appear for executives, managers, or specialized employees. But once written and signed, it's enforceable for anyone. Example: a manager's contract guarantees 3 months severance if terminated without cause. The company must pay or risk breach of contract. 2. Collective bargaining agreements. Union contracts often include severance provisions. If you're part of a bargaining unit, check the agreement. Employers must comply. Example: a factory union contract provides 1 week of severance per year of service. Workers laid off after 10 years are entitled to 10 weeks of pay. 3. Company policies and handbooks. If a company has a written severance policy, even in an employee handbook, it may create enforceable obligations. Courts sometimes rule that published policies bind the employer, especially if employees rely on them. Example: a company handbook states employees terminated without cause get 2 weeks severance. If management denies it, employees may have a legal claim. 4. Mass layoffs and the WARN Act. The Worker Adjustment and Retraining Notification, WARN, Act requires certain employers to give 60 days notice before mass layoffs or plant closings. If notice isn't given, employers may owe back pay and benefits equal to the violation period. This isn't technically severance, but in practice it functions like it. Example: a factory with 200 workers shuts down overnight. Under WARN, employees may be owed 60 days of pay. 5. State laws. Some states go further. New Jersey requires severance pay, 1 week per year of service, when employers lay off 50 or more workers. California doesn't mandate severance but requires immediate payment of final wages, and some local laws enhance worker protections. New York. State WARN requires 90 days notice. Failure to give notice can trigger back pay obligations. These state mini-WARN laws can make severance-like payments mandatory. Typical severance packages in practice. Even when not legally required, many employers voluntarily offer severance. Why? Because it helps reduce lawsuits, maintains goodwill, and softens bad publicity. Typical packages include pay, 1 to 2 weeks of pay per year of service, sometimes capped. Benefits, continued health insurance for a short period or subsidies for COBRA coverage. Outplacement services, resume workshops, job placement support. Payment conditions. Employers may require you to sign a release waiving legal claims. Example, a tech company lays off 500 workers. Each is offered 8 weeks of severance plus 2 months of paid health insurance, but only if they sign a waiver agreeing not to sue. When employers withhold severance. Sometimes workers are surprised to receive nothing. Employers often refuse severance when they are not legally obligated by contract, policy, or law. They claim for-cause termination, like misconduct, which may void severance promises. They are financially struggling and choose not to offer packages. Legally, this is allowed in many situations, but workers should always review whether contracts, handbooks, or state-worn rules apply. Discrimination and retaliation issues. Even if severance itself isn't required, how employers distribute it matters. They cannot offer severance selectively in a way that discriminates. Title VII. Severance cannot be denied based on race, sex, religion, or national origin. ADEA. Employers cannot use severance to pressure older workers unfairly. Special rules under the ADEA apply to waivers signed by workers over 40. They must be given at least 21 days to consider and 7 days to revoke. ADA. Employers cannot exclude disabled workers from severance benefits offered to others. Example: a company offers severance to men but not women in similar roles. That could be a Title VII violation. COBRA and health coverage severance packages often tie into health insurance. Even without severance, workers laid off from employers with 20-plus employees are entitled to continue health coverage under COBRA, though they must pay the full premium. Some severance packages include subsidies to reduce this cost. Example: a severance package offers 3 months of company-paid COBRA premiums, saving workers hundreds of dollars each month. Taxes and severance pay. Severance is considered taxable income. Employers must withhold federal and state taxes. Workers should be aware that large lump sums may be taxed heavily, but unemployment insurance rules vary. In some states, receiving severance may delay or reduce unemployment benefits until the severance period ends. Real-world cases. Case 1. A New Jersey employer laid off 100 workers without severance. Workers sued under the state's WARN law and won mandatory severance pay. Case 2. A California retail chain promised severance in its handbook but failed to deliver. Courts ruled the policy enforceable. Case 3. A company offered severance but required workers to waive all discrimination claims. One older worker challenged the waiver under the ADEA and prevailed because the waiver didn't meet legal standards. Case 4. In a mass layoff, an employer gave severance only to full-time workers, excluding part-time staff. The EEOC reviewed the policy for potential discrimination. What workers can do. If you're facing termination, here are practical steps. 1. Check contracts and policies. Do you have a written agreement? Does the handbook mention severance? 2. Review WARN rights. Were 50-plus workers laid off? If so, WARN or mini-WARN laws may apply. 3. Negotiate. Even if not required, employers may agree to severance in exchange for a smooth transition. 4. Be careful with waivers. Don't sign away discrimination or wage claims without understanding the release. Workers over 40 must get time to consider under the ADEA. 5. Apply for unemployment. Severance may delay benefits in some states, but you should still apply immediately. 6. Seek legal advice. If you suspect discrimination or warn violations, consult a labor attorney. Example: an office worker laid off with no severance checked her state warn law. Because the company failed to give notice, she filed a complaint and recovered 2 months of pay. The bigger picture. Severance pay is one of the most misunderstood topics in employment law. Many workers believe it's automatic. Many employers exploit that misunderstanding to cut costs. The reality is nuanced. Federal law doesn't mandate severance, but contracts, unions, company policies, and state laws can. And even when not required, severance is often used strategically by employers. For workers, the lesson is clear. Don't assume, don't guess. Ask questions, review policies, and know your state's rules. Severance may not be a guaranteed right, but knowledge can turn no into maybe, and maybe into yes. So, do you have the right to a severance package? For most U.S. workers, the answer is not automatically. The FLSA doesn't require it, and many employers provide nothing. But contracts, union agreements, company policies, and laws like the WARN Act or New Jersey's mini-WARN can create real entitlements. The bottom line, severance is not guaranteed, but it is negotiable, enforceable when promised, and sometimes required by law. Before walking away empty-handed, check every angle: contracts, handbooks, state laws, and WARN rights. If this video clarified your rights, share it with coworkers. The more workers understand severance, the less employers can use confusion to their advantage.